How is property divided in a divorce? Is it 50-50? Does it matter if my spouse was a jerk? What about if I was a jerk? What about debt? How is property divided in a divorce? We're going to get that all straightened out for you in a minute. My name is Robin Grain. I am a divorce mediator certified by the state of Virginia. I am also a certified divorce financial analyst and a former divorce attorney. I have 2 adult children that I raised as a single mom, and I even threw a second divorce in there just to make sure I knew how that works. Just kidding. Anyway, I've been in this business a long time. So how does property get divided in a divorce? Well, we got to break it down into the key elements so we can see what we have. So if you come in and mediate with me or somebody like me, we got to lay the property on the table. We usually refer to them as assets because property can get confused with real estate, but same thing. So the first thing that we have to do is determine, what is the property? Is it a house? Is it an ETF investment account? Is it a savings account? Is it a pension? What is it? That's the identification of the asset. Number 2, we're going to look at the value of that asset. If it's a house, we got to start somewhere. You're going to have to agree on the value, or we can table it till you get a professional appraiser. It doesn't really matter for our purposes in this video, but we got to get a value sooner rather than later. Sometimes it's just the balance in the account. Sometimes we have to factor for the fact that one asset is a taxable asset, such as a 401k, and one asset is not, such as a savings account. So we need to drill down to the value, and that's what a good mediator will do, will help you figure that out. Number 3, when was the asset acquired? Was it acquired before the marriage? Was it acquired after the date of separation? When is it some of each? This can get really a lot of conversation and litigation can be had about whether this asset was acquired during the marriage, depending on what your state defines a marriage as. In Virginia, that's date of marriage to date of separation, which can be a little bit of a wiggly line, but that's okay. We always get that date of separation figured out in divorce. But once we determine which of that asset, all or some of it, belongs to the marriage, that's on the table for division and distribution. The non-marital components, the premarital components, the after separation components wouldn't ordinarily be on the table to be divided up, but you can put them on there if you want to. A judge can't, but in mediation you can. So once we determine what it is, what's it worth, when was it acquired, now we start slicing and dicing. And as I always, here's the key part you've been waiting for, as I always say to my clients, if you are not dividing the total value of your assets, property, your assets and debts, liabilities, same thing, 50-50, you need to have a really good reason. Which doesn't mean you have to prove the good reason. It would if you went to court, but in mediation, you got to have something to say about why you're not 50-50. Are we a 50-50 state? No. There are, I think, 9 states in the country that the law is automatically 50-50 on marital property. We're not one of them. Nobody on the East Coast is one of those states. It is equitable distribution, which means fair, which usually means 50-50. That is the legal culture, not the law. So once again, 50-50 is the norm. We can slice and dice it however we want. Horse trade assets, that type of a thing. But if you don't want it to be 50-50, have a very good reason why not. Or just to have it agreed between the 2 of you that you think if you sweat for your 401k, you get to keep it. That's legitimate, as long as you agree. I hope this is helpful to you. Please hit that like button, hit the subscribe, hit that little bell, because I'm making a lot of great content in 2024 and I don't want you to miss it. Take care.